Yes, Your Honor, I would just like the record to indicate that I understand we did not follow up with this after the lunch break on the record, but it was my understanding that Mr. Brooks did receive the medical attention that he was seeking over the lunch hour. So I just wanted that on the record. And then finally, Your Honor, just a reminder to Mr. Brooks as to the other acts evidence. In line with his questioning of Corey Runkle yesterday, Erica Patterson will be testifying here this morning. The court issued a ruling as to the other acts evidence. The state strictly abided by that. Mr. Brooks came very close several times to opening the door to that testimony. We treaded very lightly on purpose to be respectful of the court's ruling. But the court warned him twice. Mr. Witchow even personally went over and warned Mr. Brooks during Ms. Runkle's testimony. And before we start another round of challenges, potentially during Ms. Patterson's testimony, we just wanted to make a record of that so that Mr. Brooks knows if he opens the door to that other act's testimony, it will come in.
And I appreciate the state raising that as well. Mr. Brooks, on the issue of medical attention, did you see the jail nurse or other medical personnel during the lunch hour yesterday?
Yes, I did. I received a cleaning of my cut and a bandage.
All right, thank you.
Oh, I'm sorry. I was getting to the other parts of the injuries. They
Go ahead.
viewed the bruises that I have on my arm and legs as well. I don't know what's going to happen behind that, but I was looked at.
All right, thank you. Does not appear to me that any of these injuries are interfering in any way with your ability to be here today and assist in your own defense. So that's good.
Yeah, I'm just a little tender, just a little sore. So.
All right. Mr. Brooks, do you understand what the state is referencing as it relates to the other acts evidence?
I do not understand.
Do you recall being in court at the end of August when the court addressed a number of motions, including a motion brought by the state to admit other acts?
And with all respect, Your Honor, this whole process is very, very new to me. So I'm trying to, I guess, stay within bounds of the questions that I'm allowed to ask. If I color outside the line, so to speak, it is not intentionally, because I'm basically learning as I go.
So I'm going to have my clerk print out the motion for other acts that was filed by the state, along with the response that was filed by your attorneys at that time, and further advise you the court did not grant the state's request to admit other acts as it relates to your conduct with Erica Patterson prior to November 21 of 2021. And your questions yesterday of Ms. Runkle could have opened the door to the court revisiting that issue. That's why the court stopped. It was interesting. Ms. Runkle clearly was advised not to talk about other acts. The state followed the requirement that they advise their witnesses about the court's order as it relates to other acts. And I believe I kind of paused twice and said, "Are you sure you want to answer that?" I referenced generally some prior rulings so as not to alert the jury to anything more than that. And then at one point, Attorney Witchow also came over, muted your microphone. I don't know what was said, but my understanding is he basically kind of gave you the same caution. There's a ruling, something to that effect. And I know you didn't proceed with the questions that you had originally attempted to ask this witness. So it's very clear what we're talking about. Again, I'm going to give you these filings so that you understand what I prohibited in this trial. And the record should reflect those filings are being provided. Madam Clerk, do you happen to have the document numbers for those? Sorry, I should.
170.
Document 170.
And 161.
161. So documents 170 and 161 were provided to Mr. Brooks. So the only other thing I'll say on that, sir, is if you ask questions, I'm not going, that would open up the door potentially, or at least ask questions that call for answers that might fall within that order that I issued. You do that at your own peril, and you may open the door to the state bringing in other witnesses and other testimony about those issues. So I want you to be advised of that. You are correct that when the state made the request, I prohibited the state from introducing that evidence. So you're not incorrect when you say I didn't, when you kind of referenced about there's a difference between me prohibiting you and prohibiting the state. But from my perspective, the order that I issued was to your benefit. And so you can ask those questions. You're not prohibited, but then you potentially open the door to that information becoming admissible in this case. So I want you to be advised of that.
May I quick, Your Honor?
Go ahead.
I'd just like to say that I accept for value in return for value these filings. I do believe that I have a little bit more clarity, if that helps.
Thank you for putting that on the record. Do you have any other issues you want me to address?
Just very, very quick. I still don't understand the nature and cause of the charges against me, Your Honor, and I still would motion for, or tennis motion for the jurisdiction to be proven, the subject matter jurisdiction. And also a motion for finding of fact.
Your requests are all noted for the record, and for the reasons previously stated on this record, I'm not going to answer those requests any further. They've already been denied by the court. I point you to the case of, can I have my post-it note back? The Beneby decision at 654 F 3rd 753. All right, anything else, sir?
I'm not interrupting, am I?
No, I'm asking you a question.
Just for the record, Your Honor, I would like the record to reflect, is that a judicial determination that you are making?
Your Honor, Mr. Brooks, the record speaks for itself. I've made my decision. We're moving on. All right. With that, then, state have a witness available to be called.
We do. Would you also just make a record, Your Honor, this morning that Mr. Brooks does appear again in his orange jail uniform, and that he was offered the ability to wear street clothes and declined that offer? Also, he does have appears to have all of his discovery materials at the table with him.
Yes, thank you. I should make a record of that as well. I didn't state at the outset Mr. Brooks is here in person and in custody. He once again has come to the courtroom in jail attire. I presume, Mr. Brooks, but please confirm for me, you were offered the opportunity to change into street clothes?
As I stated on the record yesterday, I'm waiting for the results of the COVID test that I took. So until I get those results back, I would prefer to not wear street clothes at this time.
All right. Can you confirm for me, though, that you were provided an opportunity to change into them if you so chose?
And not to my knowledge.
Sir, I'm providing you with that opportunity right now. If you would like to change into your street clothes into the suit and tie that you had previously or any other street clothes, I would give you that opportunity. Did you hear me advise you of that just now?
I might consider it. Maybe I may have more information from the medical staff once we take a break, or maybe I'm anticipating. Well, actually, I anticipated that I would know before we even started court. So that.
Do you want me to have the bailiffs ask the CO if there's any new information that can be relayed to you before we bring the jury out?
That would be helpful, Your Honor.
Do you have any objection? I could email the jail administrator if you want, or I can just simply have the bailiffs do that.
Whichever works best for Your Honor.
All right, let's see. She's not going to give me information in an email, that much I know, but I could at least find out if there's new information. If there's new information, then it's going to have to be given to you directly. That may require you to be taken into the holding cell to be given that information, okay?
I'm okay with that.
Okay. Let me just continue that. Again, right now he's in the jail attire. We're going to give him an opportunity to see if there's any update regarding the testing that was done earlier this week. And until we at least get word whether there is new information or not, we'll not bring the jury out. I will make a record that Mr. Brooks does have the 3 boxes that have been referenced previously. I see the objection sign. I see the selected statutes that the court provided to him previously, and I see he has a number of papers in front of him. So he looks as if he's prepared to participate meaningfully today.
May I say something real quick for the record, Your Honor?
Sure.
I did bring these boxes up. I have not had the time to go through everything in there. As you can see, it's a lot. That's putting it minimal. A lot. So I have not had the time to go through everything that's in there. I'm winging it, Your Honor.
Deputy Wittig, any new information?
Yeah.
All right. Well, can you provide that? Well, let me just see.
We'll just do it.
All right.
Can make it up.
All right, the information that I have on whether there's new information is they don't have the results, but medical will be called again to check on that, to see if anything any new information is available, but as of right now, there's not. I also was advised that you were offered 3 times to have street clothes by Officer Gabor. Just want to make a record of that. All right, then, Mr. Brooks, we don't have apparently new information. I intend to just continue then, okay?
Really quick. To the decision of Your Honor for me to be removed from the proceedings over the last few days, that was used from the Illinois versus Allen, right?
Correct.
I also had cited to a case that I believe is on point, although not binding on this court. I am persuaded by the reasoning in United States versus Jennings, found at 855 F Sup 1427, which is from 1994, from Pennsylvania. And as well as, just that one. That was affirmed by the Third Circuit in United States v. Jennings, 61 F 3rd 867, Third Circuit, 1995. So the first decision I referenced was a federal district court decision, and then the Third Circuit decision. Let me know if you need those citations again.
Does any one of those mention the being present through audio and visual?
Yes, audio. In other words, the
Would that be
defendant in that case, who also was a pro se defendant, was removed from the courtroom after he said he would continue disruptive conduct in the presence of prospective jurors, but he was able to continue to listen to proceedings through loudspeakers and transmit messages to the court, was barred, and what the court held is he was barred from the proceedings by his own conduct, not by the court, and the conviction in that case was affirmed. Do you want that citation again?
No, I'm not interrupting, am I?
No, go ahead.
I do represent myself pro per. I would like that stated for the record. Like the record to reflect that, not pro se.
The record will so reflect your choice of term to describe your appearance today.
I've briefly read Illinois versus Allen. It didn't say, it didn't give any reference at all to him being present by audio or visual in that case whatsoever. It just strictly talks about the reasons that he was removed and the options that the judge had in that. One of them being that he could be bound and gagged. One of them being that he can be held in contempt and removed from the courtroom while the trial would continue, but it did not say anything about being present visually or audio or by audio.
Well, I appreciate you reading the case, sir, and providing that information. I'm well aware of what the case says, and as that case says, the Supreme Court talked about there would be no one formula for maintaining the appropriate courtroom atmosphere, and no one formula will be best in all situations. But the Supreme Court said this: we think there are at least 3 constitutionally permissible ways for a trial judge to handle an obstreperous defendant like Allen, going through the 3 things that you identify. And my findings here are that there's a 4th way, and that's through the wonders of technology that weren't available in 1970 when that decision was authored. So I appreciate the notation on the record. You are here today, and I hope you stay here today. That's certainly my preference. You've demonstrated you're able to prepare, you're able to ask questions, you're able to articulate in a clear, coherent, cogent, and responsive way. And I'd like to bring the jury out, and that's what we're going to do next.
I'm interrupting real quick. I just want to say something very quick to that.
Very quick, sir.
I don't see that 4th way, Your Honor. Also, when
Mr. Brooks, my decision stands from previous. If you believe there's any error that I made, that is for you to address if there is a conviction and on appeal. But my decision stands, and the record speaks for itself. May
I put on record that I intend to appeal that judicial decision, Your Honor?
Understood. You may appeal as you deem appropriate.
Thank you.
All right, thank you. Let's bring the jury out. I will ask everyone stand for the jury out of respect for them.